It is 10 a.m. in New York City, where we are tracking some breaking news in former President Trump's criminal trial. The judge overseeing the case has made a decision regarding Trump's gag order violations. So joining us from outside the courthouse is CBS anchor and national correspondent Errol Barnett. All right, Errol, what'd the judge say?
Hey there, Vlad. Well, Judge Juan Merchan began today's proceedings with what he described as a little bit of good and bad news for former President Donald Trump. We'll start with that bad news and the headline. Judge Juan Merchan has found that Donald Trump violated the gag order placed on him 9 out of 10 times that the prosecutors allege he had done so. And as a result, he is now fining Trump $1,000 per violation. So fast math shows us that's a $9,000 fine and being held in contempt of this courtroom for consistently violating the gag order by attacking jurors in this case or potential witnesses. What you could describe as good news from the judge as well is that he's allowing...
John is here, and what I found out today is hard to believe. A federal judge told Trump's DOJ lawyers in open court, that isn't a threat. That's a promise warning he will hold them in contempt if they continue to defy orders on the Epstein files. The message is clear. The executive branch is not above the law, and enforcement is coming. The judge's direct, forceful language signals that judicial patience has reached its limit, and his history of holding DOJ lawyers in contempt gives the warning real weight. The case is moving fast and represents a fundamental test of whether the executive branch will comply with the law. Let's establish exactly what happened at that critical hearing, because the specifics matter enormously here.
Proceedings to be adjourned May 17th, and that's so Donald Trump can attend his son Barron's graduation, which Trump has said he has other things to do and wants to be able to attend that graduation. The one thing we haven't heard, though, if you remember last week, prosecutors brought forth more evidence of 4 additional gag order violations they say took place last week. As far as I understand, there will be a hearing on Thursday morning to address those violations. So this day, starting with some bad news for Donald Trump, now fined $9,000 for violating the judge's gag order.
$9,000 isn't a huge amount of money for a guy like this, especially considering, these are for violations. These are for a certain set of violations, but as the judge was considering those violations, he was also allegedly violating the gag order. And, so I wonder, if the judge is sort of limited in terms of things that he can do to try and limit the former president from violating these orders. Is it just fines? Because he can't really throw him behind bars.
Getting them wrong in either direction, overstating or understating, changes the entire meaning of the story. Senior U.S. District Judge Emmett Sullivan held a hearing focused squarely on the Justice Department's compliance with the Epstein Files Transparency Act and with Sullivan's own prior orders in this case. At that hearing, Sullivan pressed DOJ lawyers on 3 specific, concrete problems that had emerged in the government's handling of the document production. First, the government had not adequately documented its reasons for names it had redacted in the released records. Second, handwritten FBI interview notes that should have been part of the production were simply missing from what the government had provided. Third,
well, it's a great question, Anne-Marie. The judge has many options at his disposal, from a verbal warning, a fine per violation, and also placing Trump in jail for 30 days. These are the types of things judges all across the country do when defendants are found to be attacking or intimidating potential witnesses or jurors. It could effectively derail the entire trial. But at the same time, as we've made clear, for Donald Trump, the courtroom is the campaign trail. He's fundraising off of every proceeding each day. He has organized to have supporters here in the public space near the courtroom to chant for him, to wear his hats, to cheer for him. There's been a bit of a motorcade, you could say, of MAGA Trump trucks and cars passing behind us this morning, which we hadn't seen last week. And so the judge is likely keenly aware that if he were to punish Trump to the maximum, let's say put him up for 30 days during what is the first criminal trial of a former president.
The government had missed a requirement to publish its redactions and the reasons for them in the Federal Register, which is the official journal of the federal government's rules and regulatory actions. These are not minor technicalities. These are three specific, concrete, fully documented compliance failures in the same case. And Sullivan made it abundantly clear that he was not satisfied with the explanations being offered. According to Courthouse News, he told the government lawyers directly that the public had a right to know what the hell is going on in this case. Those are not the words of a judge who is mildly concerned.
Trump would use that in some ways to his benefit. And so I think both the delay of a decision and now finding Trump 9 out of 10 of these gag order violation charges in some ways is the judge trying to find a type of middle ground that sends a signal to Trump that if you continue to do this, there will be more punishment, but does not necessarily feed into Trump's narrative that he is the victim here and is just part of a grand conspiracy from the left, which he continues to say both on his Truth Social platform and via his fundraising emails.
And so who's testifying today, Errol?
Well, we've got the official custodian of records for Michael Cohen, Gary Farrow. He was Michael Cohen's banker at the time. That's what's getting underway this morning. And he's confirming some of the times, dates, and amounts that we heard David Pecker, the former publisher of the National Enquirer, spell out last week. He helped set up limited liability companies that Michael Cohen was able to facilitate payments to Stormy Daniels through, specifically the $130,000, of which Donald Trump reimbursed through.
Those are the words of a judge who is genuinely frustrated, who has seen the same pattern of noncompliance repeated, and who has decided that the time for patience is running out. The message was unmistakable. The court expects compliance, and the court will not accept excuses indefinitely. Now, let's be precise about what the contempt warning actually means, because this is the part that is getting misread in both directions in the coverage. Sullivan did not hold Trump personally in contempt. Let me say that clearly and without any ambiguity. This contempt warning was directed at the Justice Department.
Line items called legal fees, and that's the backbone of this trial, these 34 felony counts. And so the jury went into the weekend kind of absorbing what seemed like the legitimate testimony of David Pecker, buttressed by Rona Graff, who was Trump's assistant, and confirmed that Trump put Stormy Daniels and Karen McDougal's contacts in his contact list, and Gary Farrow, who ended last week and started this week by kind of connecting the dots and saying there was a real sense of urgency from Michael Cohen before the 2016 election to set up these accounts and get that money to Stormy Daniels so that her story of an alleged affair wouldn't reach the public. And that's why prosecutors believe this isn't just a hush money case. It's an election interference case because the money was made to suppress a story that the American public couldn't see in order to make a decision about that election. And so we expect other witnesses to appear this week that will help fill in some of those blanks. And also just what's noteworthy is that Donald Trump's son, Eric, is in the front row of court proceedings today. We haven't seen the Trump children inside just yet, but it continues to be a significant week for the former president.
At the government's legal team, at the executive branch agency responsible for complying with the court's orders. It was not directed at Trump as an individual. And critically, Sullivan has not yet held anyone in contempt. What happened at that hearing is that he signaled clearly and explicitly that contempt proceedings are a real option, that he is prepared to pursue them if compliance does not improve, and that his statement was not a threat, but a promise. He also invoked his own history of actually doing this. Sullivan held Justice Department prosecutors in contempt in the 2008 Ted Stevens corruption case. He knows how to do it. He has done it before. He is not bluffing. The DOJ lawyers in that room understood that when a judge cites a specific historical instance in which he took exactly the action he is now warning about, that warning carries a level of credibility that a purely theoretical threat does not. Sullivan's reference to the Ted Stevens case was not a casual historical footnote. It was a direct message that he has been down this road before, that he knows exactly what contempt proceedings against government lawyers look like, and that he is willing to walk that path again if the circumstances require it. That is a powerful message from a powerful judge, and it should not be underestimated. Let me give you one more layer of background that is essential for understanding why this case matters beyond the Epstein and Trump angle. On a previous date, Sullivan ruled that the Justice Department had effectively conceded It was violating requirements under the Epstein Files Transparency Act. He issued a preliminary injunction requiring further compliance. Let that sink in for a moment. The Justice Department, in a prior proceeding in the same case, effectively conceded to a federal judge that it was not following a law passed by Congress. That concession is now part of the official court record. The recent hearing was the follow-up, where the court checked whether the agency had corrected its course and found that it had not fully done so. The trajectory of this case is a federal court finding a compliance violation, ordering correction, and then finding at the next hearing that the corrections were still inadequate. That trajectory is what creates the conditions for a contempt proceeding. And it is why Sullivan's promise carries so much legal and institutional weight. Here is what most people are missing about this story, and I think it is genuinely the most important analytical point. This case is not primarily a story about Trump personally. It is a story about whether a government agency will comply with a law passed by Congress and with orders issued by a federal court. Those are two of the most foundational tests of how a constitutional democracy actually functions in practice. Congress passes a law requiring disclosure. The executive branch, through the Justice Department, is responsible for carrying out that law. A federal court, when asked to enforce the law, reviews whether the executive branch is complying. And then the court does what courts do. It decides whether the compliance is adequate. When it is not adequate, as Sullivan found in the earlier ruling, the court orders correction. When the correction is still inadequate, as Sullivan indicated at the recent hearing, the court's next available tool is contempt. This is the constitutional system working as designed. The three branches of government, legislative, executive, judicial, each playing their assigned role. And right now, the judicial branch is telling the executive branch that it is not complying with what the legislative branch requires and that it is going to enforce compliance. That is not a partisan story. That is a structural accountability story. It is about whether the system of checks and balances actually works in practice or whether it exists only on paper. The answer to that question has profound implications for the future of American governance. Let me give you the background on the Epstein Files Transparency Act specifically, because most coverage is treating it as a given without explaining what it actually is and why Congress passed it. Jeffrey Epstein, the financier and convicted sex offender who died in federal custody, had extensive connections with powerful figures across politics, finance, entertainment, and royalty, spanning multiple decades in multiple countries. His death, ruled a suicide, was immediately and widely contested, with significant public skepticism that has never fully dissipated. In the years following his death, court proceedings related to his co-conspirator and civil cases brought by his victims produced significant document productions, but not the complete picture of everything the government knew about Epstein, his network, and his activities. The Epstein Files Transparency Act was passed to address that gap. It created a legal mandate that the government release records related to the Epstein investigation, rather than holding them indefinitely under general classification or law enforcement sensitivity grounds. It represented a congressional judgment that the public interest in understanding what happened and who was involved outweighed the executive branch's discretion to keep those materials under wraps indefinitely. The law passed with bipartisan support precisely because the Epstein case had cut across political lines in a way that generated rare cross-partisan agreement that the full record needed to be public. What Sullivan is now enforcing is not a partisan demand. It is a bipartisan law that Congress passed. And the question of whether the executive branch will comply with it is a question about basic institutional accountability rather than political alignment. Let's dig into the three specific compliance failures Sullivan raised at that critical hearing, because the particulars are more interesting and more revealing than the headline number of failures suggests. The first, inadequate documentation of names redacted in released records, is significant because the Epstein Files Transparency Act requires the government to justify its redactions. Redacting a name without documenting why the redaction is legally justified is not just an administrative oversight. It is a failure to meet the specific procedural requirement that allows a court to evaluate whether the redaction is legitimate. When the government redacts information without providing the required explanation, it is effectively asking the court to take on faith that the redaction is valid rather than demonstrating it. Sullivan is refusing to do that, as he should. The second failure, missing handwritten FBI interview notes, is potentially more significant. FBI interview notes, commonly known as 302 seconds, are among the most sensitive and valuable documents in any federal investigation. They record what witnesses said to investigators. They are exactly the kind of documents a transparency law about the Epstein investigation would be most valuable for releasing, because they capture what people actually told the government about what happened. Their absence from the production is not a minor clerical issue. It is a gap in the most substantive part of what the transparency law was designed to surface. When the government fails to produce these notes, it is withholding the very evidence that would allow the public to understand what investigators actually learned during their inquiries. The third failure, missing the Federal Register publication requirement, is a procedural one, but it matters institutionally in a specific way. The Federal Register requirement exists so that the public and interested parties can track what the government is doing with its redaction decisions, not just see the redacted documents, but understand the rationale for what was withheld and have the opportunity to challenge those rationales through appropriate channels. Missing that requirement is not just failing to file a form. It is failing to create the public accountability record that the transparency framework depends on. When the government skips that step, it undermines the ability of journalists, lawyers, and ordinary citizens to evaluate whether the redactions are legitimate. And in a case that is specifically about whether the government is being transparent enough about Epstein-related records, failing the basic procedural transparency requirements is a particularly pointed kind of irony. Now let's talk about Judge Sullivan's decision to invoke the Ted Stevens case, because I think it is one of the most important moments of that hearing, and it deserves more attention than it is getting. The Ted Stevens case was a federal corruption prosecution involving the late Republican senator from Alaska. The case became notorious, not ultimately for the conviction, but for the prosecutorial misconduct that followed it. Justice Department prosecutors were found to have withheld evidence from the defense and to have otherwise mishandled the proceedings in ways that resulted in Sullivan holding those prosecutors in contempt. The case ultimately ended in dismissal of the charges and a Justice Department investigation of its own conduct. Sullivan said in the recent hearing that he did not want to go through that experience again. That statement is doing two things simultaneously. It is expressing genuine reluctance to take the drastic step of contempt, which is a sign that Sullivan is not looking for an excuse to escalate. And at the same time, by invoking a case in which he actually did hold DOJ prosecutors in contempt, it demonstrates beyond any doubt that he is willing and able to do it if the circumstances require it. The message to the DOJ lawyers in that room was unmistakable. I have done this before, and I will do it again if you give me no choice. That combination of reluctance and resolve is exactly the kind of judicial posture that historically gets compliance, because it signals the court is acting from principle rather than from political motivation. Let's also think about what the government's position in this case reveals about how the Trump administration is approaching the tension between transparency obligations and political sensitivity. The Epstein files contain materials that reference many powerful and well-connected people, including the sitting president. The administration faces a genuine institutional tension between its legal obligation to release those materials under a transparency law and its obvious political interest in controlling the pace and scope of what gets released about a topic. That has been politically damaging. That tension does not justify violating a transparency law or defying court orders, but it does explain why compliance in this case has been slow and contested. When Sullivan presses DOJ lawyers on missing documents and inadequate explanations, he is pressing on exactly that tension. He is saying the law requires disclosure, the court has ordered it, and the government's political preferences about what to release and when do not constitute a legal justification for noncompliance. That is the fundamental message of everything that has happened in this case, from the preliminary injunction through the critical hearing. The court is saying that the executive branch must comply with the law, regardless of whether compliance is politically convenient. This is not a radical position. It is the foundation of the rule of law. But it is a position that needs to be enforced when the executive branch shows signs of resistance. And that enforcement is exactly what Sullivan is signaling he is prepared to do. There is one final dimension of this case that I want to make sure you have the full context on, because it connects the Epstein files litigation to the broader pattern of how this administration has approached transparency and document compliance across multiple areas. We have covered in prior coverage the administration's approach to press access, the press pool changes, the cabinet meeting exclusions. We have covered the records preservation injunction that a federal court issued requiring the White House and DOJ to comply with the Presidential Records Act after concerns about disappearing messages. We have covered the numerous court losses on voter roll access requests and the many adverse First Amendment rulings. The Epstein files contempt warning is part of that same larger pattern. An administration that has repeatedly been found by federal courts to be out of compliance with legal requirements and has repeatedly been ordered to correct course. Each individual case has its own specific legal context and its own specific facts, but the pattern across all of them is consistent. Courts finding that the administration's approach to legal requirements and disclosure obligations is inadequate and ordering compliance that the administration then contests or delays. That pattern is the story underneath the story, and it matters. Understanding what the Epstein files case represents, not just as an isolated transparency dispute, but as another data point in an accumulating body of evidence about how this administration relates to legal obligations it finds politically inconvenient, is essential for understanding the broader constitutional moment we are living through. Let's think about what happens when an administration consistently resists compliance with court orders and transparency laws. The immediate consequence is that specific cases drag on, documents are delayed, and public access to information is restricted. But the deeper consequence is that the norms of institutional accountability begin to erode. When one branch of government repeatedly disregards the requirements of the other branches, the entire system of checks and balances starts to break down. And when that breakdown happens, the rule of law itself becomes contingent on the willingness of courts to enforce compliance. That is why Judge Sullivan's warning matters so much. It is not just about Epstein files. It is about whether the judicial branch will stand up for its own authority and for the constitutional order that depends on that authority being respected. The recent hearing was a moment where the court drew a line in the sand. Sullivan told the Justice Department that its compliance failures were unacceptable, that the public has a right to know what is happening, and that contempt is a real possibility if things don't change. That line in the sand represents a test of the entire constitutional system. Will the executive branch comply with the court's orders? Will it respect the authority of the judiciary? Or will it continue to resist, forcing the court to escalate its enforcement measures? The answer to those questions will tell us a great deal about the state of American democracy in this moment. Let's break down the 4 clear points that give you the complete picture of where this case stands, what the contempt warning means, and what comes next. First, the contempt warning is real and significant, and Sullivan's history makes it credible in a way that most judicial warnings are not. Sullivan told DOJ lawyers that compliance failures could result in contempt proceedings, and he invoked the Ted Stevens case to make clear this is not an empty threat. He has held Justice Department prosecutors in contempt before. He did it in a high-profile federal case involving a United States senator. He is not a judge who treats contempt as a theoretical last resort that he would never actually use. He is a judge who has actually used it when he found executive branch lawyers were not following the rules. The fact that he brought up the Stevens case himself, unprompted at this specific hearing, is a signal that he wanted DOJ lawyers to understand that his reference point is not hypothetical. He knows exactly what contempt proceedings against government lawyers look like because he ran them. The DOJ attorneys in that courtroom understood what they were hearing. And the fact that Sullivan explicitly said, "This is not a threat, this is a promise," means the court is signaling that the patience for explanations without corrections is running out. Contempt of court for a government agency in this context would mean fines, mandatory compliance deadlines, and an escalating pressure campaign that the Justice Department would need to actively manage. It would not mean jailing Trump or any individual official, but it would mean the court is actively enforcing its orders through sanctions rather than persuasion. The 3 specific compliance failures Sullivan identified tell you what the government has actually been doing or not doing with the transparency law. Missing FBI interview notes, inadequate redaction documentation, failure to publish in the Federal Register. Each of these is not an accident of volume or complexity. Each is a specific procedural failure in a process that the transparency law and the court's prior orders laid out clearly. When a government agency misses specific required steps in a court-ordered compliance process, in a politically sensitive case, there are 2 possible explanations. The first is genuine administrative difficulty. The volume of material is large. The process is complex. Errors happen. The second is that the pace and scope of disclosure is being managed for reasons beyond pure administrative capacity. Sullivan is not accepting the first explanation without verification. And the recent hearing was his way of making clear that the government needs to do better on the specifics rather than offering general assurances of good faith. He is demanding concrete evidence of compliance, not just promises of future cooperation. And the fact that he had to demand that evidence in open court tells you that the government had not been providing it voluntarily. The preliminary injunction is the foundation that makes the contempt warning meaningful. Sullivan did not arrive at the recent hearing fresh. He had already issued a preliminary injunction after finding that the DOJ had effectively conceded it was violating the transparency law. The recent hearing was a follow-up to that injunction, an opportunity for the court to assess whether the agency had corrected its course. Finding new compliance failures at the follow-up hearing after an injunction has already been issued is the specific procedural posture that makes contempt a realistic next step rather than a hypothetical one. The government has now been told twice in the preliminary injunction ruling and at the recent hearing that its handling of these materials is not adequate. A third failure would leave the court with very little option besides enforcing the injunction with sanctions. That escalating pattern is what gives the recent hearing its real weight. This case is a test of a foundational constitutional principle, and the outcome matters beyond the Epstein files specifically. The core question in this litigation is whether a federal agency will comply with the law Congress passed and with orders a federal court issued, even when the subject matter is politically sensitive and potentially damaging to people connected to the current administration. That question recurs constantly in the relationship between the 3 branches of government, and the answer courts give to it shapes the practical meaning of constitutional constraints on executive power. If the court enforces compliance, including through contempt if necessary, it reinforces the principle that executive branch agencies are not above the law, regardless of the political sensitivity of what the law requires them to do. If enforcement fails for whatever reason, it creates a precedent for noncompliance that goes well beyond this specific case. Sullivan's promise of contempt is ultimately a statement about which of those outcomes he intends to allow. He is signaling that he will not allow the executive branch to ignore the law or the court's orders. He is signaling that the constitutional system of checks and balances is not a suggestion, but a requirement. And he is signaling that he is prepared to use all the tools at his disposal to ensure that the law is followed. That is the message that the Justice Department lawyers heard in that courtroom, and that is the message that the entire country should understand. Let's also consider the broader implications of this case for the future of transparency in government. The Epstein Files Transparency Act was a landmark piece of legislation precisely because it mandated disclosure of information that the government might otherwise have kept secret. It represented a congressional judgment that the public interest in understanding the full scope of the Epstein scandal outweighed the executive branch's desire to control the narrative. If the executive branch can effectively nullify that law through non-compliance and delay, then the entire concept of transparency legislation is called into question. Why pass laws requiring disclosure if the agencies responsible for disclosure can simply refuse to comply? Why have a legal framework for transparency if the courts cannot enforce it? These are not theoretical questions. They are the practical realities of the current situation. The government's compliance failures in this case are not just administrative errors. They are tests of whether the law will be enforced. And the court's response, up to and including the contempt warning, is a test of whether the judiciary will stand up for the rule of law. So far, Sullivan has passed that test with flying colors. He has been firm, he has been specific, and he has made clear that he will not accept excuses. The question now is whether the Justice Department will finally get its act together and comply with the law and the court's orders, or whether it will continue to resist, forcing the court to escalate its enforcement measures. Now let's think about the practical consequences of a contempt finding against the Justice Department. Contempt of court is not a minor sanction. It would mean that the court has found the government in willful violation of its orders. That finding would carry serious reputational damage for the agency and its leadership. It would likely trigger fines that would need to be paid from the Justice Department's budget. It could lead to judicial monitoring of the agency's compliance efforts with a court-appointed official overseeing the process. And it would send a powerful message to other government agencies that non-compliance with court orders carries real consequences. In short, contempt is not a step that any court takes lightly, and it is not a step that any agency wants to experience. But contempt is also not the only tool the court has at its disposal. Sullivan could also order the production of specific documents by specific deadlines, with escalating sanctions for each missed deadline. He could require personal appearances by senior DOJ officials to explain why the agency is not complying. He could refer the matter to the appropriate oversight committees in Congress. The range of enforcement options is broad, and the court has significant discretion in how it chooses to exercise its authority. That discretion is what makes the court's warnings so powerful. The government knows that the court has options, and it knows that Sullivan has a history of using them. The recent hearing was a watershed moment in this case. Sullivan made clear that the government's compliance failures are unacceptable. He made clear that the public has a right to know what is happening. He made clear that contempt is a real possibility. And he made clear that his words were not an idle threat, but a promise. The government now has a choice. It can comply with the law and the court's orders. It can produce the missing documents, document its redactions, and publish in the Federal Register as required. Or it can continue to resist, forcing the court to follow through on its promise of contempt. That choice will determine the outcome of this case and will send a powerful signal about the state of the rule of law in America. Here is the bottom line on everything we just walked through. A senior federal judge with a documented, specific, on-the-record history of holding Justice Department prosecutors in contempt in a case he explicitly named in open court, just told Trump administration lawyers that he is prepared to do it again. The warning was not theoretical. The judge's track record is not hypothetical. The compliance failures are documented and specific. And the trajectory of this case, from the preliminary injunction through the recent hearing, is one of escalating judicial frustration with escalating noncompliance. That warning was specific. It was credible. It was grounded in 3 documented compliance failures. And it was delivered by a judge who has earned the reputation for following through on exactly this kind of statement. The contempt fight is not here yet, but the conditions for it are being actively assembled. 1 missed deadline, 1 missing FBI note, 1 inadequate Federal Register entry at a time. The enforcement mechanism is key to what happens next. Will the DOJ finally comply, or will the judge follow through on contempt? The outcome will shape executive-judicial relations for years. This is a defining story of the era, and I'll track every development.